Hi, everybody. My name is Todd Herman. I am a principal with Mediasm LLC Consultants and beginning a startup that we'll talk about one day near the future. This is the first time I've been incredibly, unshakably nervous for a panel discussion in Digital Hollywood, in that I'm surrounded by lawyers who are verifiably smarter than me in just about every way. A group of business people who are going to be asked to interact with the issues of law because they interact within the ecosystem. And the topic is the emerging law of wikis and social media. So just some framework. I've decided that Jane is now special person number one on this panel because she brought breaking news. So we're actually going to have some breaking news. But before we begin with that, I want to do just the tiniest little poll to see. Raise your hand in here if y'all are content providers. Okay, well, bad news is this is actually a sting. And some kind folks from the Justice Department are here to check your bona fides. Raise your hand if you run a technology platform that deals with any of this stuff. Oh, okay, thanks. And lawyers in the audience. Right. Someone I didn't name, advertisers? No? Okay, interested parties. So, for me, the very notion of copyright, the very notion of ownership over media property has always been something I grew up with from traditional media. But about 6 years ago, I went to work for a small Redmond-based software company called Microsoft, and was working with them in the media space, starting a project called MS Video. And I got a call from a loosely affiliated, privately funded group that works with Microsoft, are actually employees but have no connection to the Death Star, right, the global home. Microsoft really actually respects intellectual property, as you might imagine, because they have a lot of it. So imagine my shock when I got this phone call from someone, Australian, who I won't name, who worked for a loosely affiliated group in Seattle building this incredible technology platform. And he brought me down to the offices because he wanted to show it to me as a media strategist and someone connected to ad dollars. And he presented to me an instance of instant messenger that would allow a couple of hundred people to watch the same television show at once and to comment on it. So look at that, Meg, isn't that beautiful? Pick any show you like. I said, MASH. He's right, oh, God, right, yeah. Search MASH. Anyone here Australian? I guess I know I'm murdering that. So I did, I searched MASH. And up came MASH episodes, and started to watch it. And around his office, people started to comment on the show. They were watching it too. I said, my God, this is amazing. When is this released? He goes, no, it's out there. Pardon? Well, I mean, we haven't promoted it, right? So I'm in a dark beta period, dark alpha. And I said this question to him. Who are you paying for the content? He goes, what do you mean, man? We have to pay for the content. He goes, why? Well, because it belongs to somebody. And I actually had to explain the notion of ownership to him. And the way I finally got him to stop was I said, you know, I have an idea. Let's take the source code for this project and put it up on MSN.com. Oh, you can't do that. It's on property. Now, that was 6 years ago. 60 minutes ago, I decided I would like to watch NBC's The Office. And so I did. Right? Not all of it, but good long clips of it. And yeah, I'll tell you where. And you don't even have to post them. 6 years ago, also, raise your hand if you know this group, adbusters.org. Anyone know those guys? Fascinating stuff. Really cool. Well done. A loosely affiliated group of designers and artists who are culture jamming. One of the culture jamming products was to reproduce the McDonald's menu, the actual paper menu, and then enter into McDonald's around the world, remove the nutritional guidelines, and replace theirs, so that when your 14-year-old wanted to know how many calories was in a Big Mac, as all 14-year-olds do, they would open the menu. They would turn to the page that had the Big Mac, and it would be the Big McMurder. And it would discuss how the cow was killed versus cooked, with the McDonald's logo right there on it. That was 6 years ago. 60 minutes ago, I logged on to a video sharing site and saw a video shot entirely in an iPod, a branded iPod, visibly an iPod. The logo was changed to Iraq. The song was by Bjork. It was full length. The images in it were logos of the US Army and other corporate brands appropriated and used in there. And it took me all of a minute to find that. Our panel are lawyers, they're business people, they're social media critics, they're social media people who work in social media. That's some examples, fairly video-centric examples. And now, for sake of drama, 6 minutes ago, roughly, Jane handed me this. Internet auction company eBay cannot claim immunity under Section 230 of the Communications Decency Act. In a suit alleging fraudulent misrepresentation in a case in which eBay affirmatively guaranteed the safety of that auction with a statement on its website. They are a content provider because they guaranteed the safety of an auction and they are liable for that. So, has it changed that much? That's what we're going to discover today. Raise your hand if you have read the Principles of User-Generated Content and can stand and quote it by heart.
Very small.
Yeah, there are a small number of people. There are about 16 rules here with some companies, Disney, Fox, Microsoft, MySpace, VO, have gotten on board with this, and yet I don't think the principles are largely understood. So with that as a frame-up, I want to throw the introductions to the panel because they know themselves better than I do. I'll give a brief introduction of themselves, why they're here, what they do, and then we will roll forth into the discussion. Special person number one.
My name is Jane Stevens. As of Monday this week, I became the acting managing partner of the brand new New York office, Russell, Silverberg, and Nupp, which we first opened. Before that, as of Friday, I was a partner at Sunshine and Rosenthal in the New York office here. I have been a litigator in the entertainment IP media space since 1978 and spent most of my career at a small litigation boutique called Gold Barrel and Marks, which no longer exists, but had a very high-profile entertainment practice here in New York City. I have represented musicians, artists, software companies, television networks, and others in the media space for the entire period of my career.
My name is John Bagley. I actually kind of approached this topic from kind of three ways. One is I'm the director of social media at Overstock.com, so I am overseeing the creation of a kind of a marketing via social media effort on the site that's turned out to be, it's actually much better than anybody anticipated. And I have a pretty decent sense for some of the challenges on that front. I'm also, and I think what more directly let me hear was, I also have a blog. It kind of deconstructs the use of social media, the abuse of social media, specifically as a platform for stock manipulation. I call it antisocialmedia.net. As a result of my blogging, there was a long time where the Wikipedia, which is the encyclopedia anybody can supposedly edit, could be edited anywhere except for the town where I live and at Overstock.com, the place where I live. And that was not because of what I was writing on it. It was not because of what I was adding to Wikipedia, but because of what I was writing about Wikipedia on my blog. I've kind of discovered, and I can get into it in great detail, some kind of startling examples of how that platform is able to be manipulated in ways that are truly damaging to companies and to individuals. And this has ended up being kind of has received some actually international media coverage as well. So I look at it that way too. I also, when I came to that, because I, in 2005, started a podcast series where I was kind of experimenting in public relations via podcasting, using that. So I also am a kind of content generator. That way I understand sort of the challenges facing the media landscape too.
So we will call Jed civil. Just Brian, pick a mic, any mic, since you don't have one.
Okay, I can shout too. My name is Brian Monahan. I'm an ad agency with technology-related IP issues, so a lot of my clients are internet companies and social media companies, but also then work for traditional entertainment companies and media companies. So I kind of have the lens and the perspective of talking to all of those people these topics today.
My name is Ian Ballin. I'm an intellectual property and internet litigator in the LA and Silicon Valley offices of McGraw-Hill, and I'm the author of a 4-volume treatise published by West, E-commerce and Internet Law. My practice involves representing entertainment companies and technology companies in internet and IP matters, and my clients range from entertainment companies, including movie studios such as Fox and Sony Pictures, traditional media companies, including the flagship newspaper chain, and technology and Web 2.0 companies, including MySpace and LinkedIn.
My name is Daniel Coomer. I'm in the NBC Universal Law Department, VP of Litigation and Content Protection. Been in NBC for almost 11 years. Most of that time as a general litigator, doing law litigation of various flavors, commercial litigation. But since the merger with Universal, NBC has become much more of a content company than it ever was before. And in the course of that transition, I took on the responsibilities of litigator, focusing on new technology, content protection, anti-piracy issues, essentially trying to make the world safe for television, the digital world, or at least to try to make it safe. And even though I'm a litigator by trade, I do relatively little actual litigation these days. It's much more advising and persuading.
Encouraging to do the right thing, Chris.
Hi, I'm Gil Pacino. I'm not entirely sure how I ended up on the lawyer's side of the table, but so I feel a little uneducated. It's nice to be here. I run Wiki, which is a company that uses the wisdom and some of the insights gained from Wikipedia to create content sites on now 6,000 topics, everything from caring with pets who have diabetes to World of Warcraft to television shows on NBC. Our users created over 1 million pages of high-quality content, and we're a media company. We sell advertising and reach about 25 million visitors a month. Interestingly, since the quote came up, in my prior career, I spent 8 years at eBay, so I've had a little bit of experience with different types of user-generated content.
Thank you. So, starting the discussion this way across, and then we'll switch around and move it randomly. Reading the principles for user-generated content services, it effectively sort of seems to me that it says, make it hard for people to upload stolen stuff, to purloin things, do your best efforts to warn them that that's really, really bad and nasty and they shouldn't do it and it's mean. Question 3 parts. 1, do users care? 2, do brands care? And 3, how much do the content companies care? I know you care, but are we going to see more lawsuits or more persuasion? So we'll start with Jane.
In my opinion, the principles that have been articulated are very fine, high moral principles, and I don't think that they are particularly observed, particularly on the user-generated sites. I don't know how much they're observed on the internet sites that do also provide internet site-generated content. The more that these sites can attract viewers, and the more interesting the material that they can contain on their site, the way that the business seems to be developing, is the more revenues that they can generate through advertising and other revenue sources. I think that there is certainly absent laws that are going to restrict their activities, that are going to find them liable for using infringing property, stolen property, and people aggressively going against these sites and holding them to their legal obligations, that moral obligations such as articulated in what we're talking about here are not going to govern their conduct. And I don't think
So, just a question before we move on to the rest of the panel. We had this has been talked about forever, but someone steals a piece of a news article, someone steals a piece of a TV show, right? And they think differently of it than if you were to actually walk into a retail retail store, pick up a copy of USA Today, say, thanks now, and walk out. Even though it's 50 cents, probably customers would have you. So where's the disconnect? How come consumers don't see this as theft or memory?
Well, we were discussing this before. I think in the privacy of your own home, without the guilt of people watching you and public perceptions, people think that they can do what they want to do. And it's kind of like you stand in front of the refrigerator and you're eating a cookie standing up. It doesn't have calories. It's kind of that same kind of mental process, and it doesn't really work. It isn't logical, but so you're sitting in your house and nobody's looking, and you're not thinking you're stealing it, and you're not thinking you're downloading it for yourself. You're not necessarily going to put it up on a peer-to-peer network and share it with other people. No harm, no foul. So I think there is a very big difference between what one does in one's own home, unless you're schooled and counseled and educated and believe in the value of property, and that what is going on here actually is theft. And what one would do out in the public forum, where people are observing and actually seeing you take something. It is obviously a process of education, and I think it's going to be an increasing problem. I know that I was working on a website for the Copyright Society of the USA many years ago, trying to come up with a way to begin to educate children at the very earliest possible time, so that they understood from the time that they first encountered the ability to download material, to be online, to have access to content, that if they copied something, it was stealing. There are programs that go into schools. The education has to begin very early on, but obviously it is a difficult world that we're operating in, where you can get this material for free. And how much are people going to be willing to pay for it, even if you are of high moral integrity, if you can get it for free?
Jed, at Overstock.com, the social media practice there, you are meticulously careful to make sure you engage in no social media marketing at any site that has any stolen material.
Well, I can think see, this is a very interesting point, because it's like, one of the challenges of Web 2.0, okay, the great part about Web 2.0 is the idea that anybody can participate. The worst part about Web 2.0 is that anybody can participate. And consequently, I think, the only way around this problem, because it is it's impossible for any committee, any group, anybody whose job it is to monitor this. I think personally, more important than making it difficult about what's going material is to make it very easy for the community to flag what's going material. And I think that most people feel like they're doing their civic duty when they have, on YouTube, for example, report with just a problem. I think that's much more likely to be the solution than to make it difficult, because it makes it easy for the community to say this kind of problem. We, and on Overstock, on our community section, can make it very easy for people to say this should not be here. Now, my concern is a little more with whether material is stolen, belongs to, was not appropriate to upload, is whether or not it is true. So when you're dealing with words, I think it should be much more easy for the community to say this is not true, and maybe this is intentionally and deceitfully not true, and to make that much more easy to act upon. That kind of the rooting out of incorrect or malicious means is kind of right. And so that too, it kind of comes back to this fact, this is inappropriate. And I think brands in particular should care very much about this, because especially if we're corporate trade company, and this information is right about the fact.
So there, and I don't know his name, I just read that a United States Senator has surprisingly thought of a law for this, that he would like to make it illegal to anonymously post on a website. Raise your hand if you agree that should be illegal. Brian Monahan in the world of brand marketing, you, of course, refuse to have anything to do with a property that has any stolen material on it, or am I correct in understanding that you don't have the time and the resources and the ability to go through and actually decide what belongs there and what doesn't, that your job is to drive impressions and to build brands? But I'm sure it's more complex for that. So, three-part question thrown to you.
Sure. Our job is to impact culture on behalf of our clients. Different brands will have different sort of risk appetites for where they'll place their media dollars. I mean, some people choose to advertise with Howard Stern, some people don't. For the most part, we make a best effort to try to find clean, well-lit spaces to place our clients' media buys. But the other sort of phenomenon of Web 2.0 is things are so syndicated, hyper-syndicated, and you're buying all these networks that sometimes you actually don't know where your Google text ad is going to show up. So despite best efforts, you may actually wind up underwriting something that you wouldn't want to. The one other point I'll just make on this notion of brands' appetite for participation in content uploading and whatnot. Increasingly, brands are viewing themselves as content creators themselves. But we actually want our content to get uploaded and used, and we're willing to take the risk of the iPod example that you cited, because we think that's sort of an acceptable issue that we can manage in the chase of the greater good, which is actually having our content spread more broadly.
And I want to dig into that a little bit too, because it's a fascinating occurrence that there's now an ability for consumers to actually define brands rather than brands sort of define themselves. Now, on the front of the lawyers, and then this kind gentleman who's not a lawyer. In fact, let's start with the kind gentleman who's not a lawyer, then let's get down to the litigation. Kind gentleman, Bill, not a lawyer, you're searching these properties, and hopefully you are coming back with relevant searches that are meaningful for consumers. A couple questions specific to that, and sort of tangentially related to this. One, do you think consumers, writers, people who contribute to wikis, really care about verifiable truth, or do they care more about they verifiably believe this should be true? And do you take any means of sort of trying to filter that with your service?
So I guess 4 questions then.
Maybe 5 or 6. Yeah. Throw them out, give a speech.
No, it's an interesting question. And I guess I always start with the notion that software can be used for many purposes, just like guns can be used for many purposes, and steak knives can be used for many purposes, right? You go to a nice steak restaurant here in New York, and they don't put bars up between people to prevent them from killing each other. There's an assumption that people are basically good and you won't kill each other given a sharp knife. Some people seem to think that given a sharp knife in the privacy of their own home, people will start killing each other. We come from a premise that people are basically good. That most people, given sufficient visibility and accountability, will be good very much of the time. So we do a few things. We track everyone's IP. We can show you who made every contribution so that you're not entirely anonymous. And we have very strict policies and rules about uploading content that's proprietary. And we actually find very few issues with people, with our users, doing anything inappropriate. I mean, I was actually asking one of our lawyers at the end of the year how many notice to take down requests we've gotten, and he wrote a hand. I don't know, 3, 5, something like that. So I think users or or people are basically good, given sufficient anonymity. I find that sometimes they're not quite as good. So when I get a really nasty email from someone, I pick up the phone, I find a much nicer person than they are by email. Just sort of basic human behavior here. As to your question of whether the consumers are doing something wrong, or?
I think my question is, do they care about truth?
So, truth is an interesting question. It's, we have, again, because of our software, we have some wikis that start with the notion that they should be documenting what's true. And they'll actually require that every piece of content on the site includes a reference or a link to the source, to be verifiable or authentic source from which it came. not verifiable if you can't find some media outlet or some company that's published on the web. They'll take it down.
So let me try and
Wait,
okay,
on the
yeah,
other
good.
hand,
Okay.
I have a Christianity wiki that starts with the notion that Jesus loves you. They think that's truth. I'm not sure, but I support their right to that notion of truth, such as it is.
Great point. So the reason I want to transition into the leverage, okay, so this notion of truth and writing what's true, you guys are in the business of words, so we kind of morphed into the wiki discussion. We get back to UGC, and I certainly want you to comment on that. I certainly want you to comment on that. So let's get through that. But let's add to this mix this idea of consumer journalism and of wikis, and we'll come back around on this. So adding to the mix of one, lawyers, do consumers care? Right? And I would liken it this way, right? Raise your hand if you've used adult content in a hotel. Oh, did I raise my hand? I didn't mean to. That's an example, because of course I didn't know it was there. Someone is. Raise your hand if you have downloaded stuff you knew to be stolen. All right. Yeah. So we'll kind of admit that, and I think most of us probably don't do that as a point of practice. So the idea of in the home, right, that privacy. In the home, do consumers care that the material is purloined? Do they care that they may not be writing truth? Is it beyond technology? Is it beyond exemptions and lawyer talk? So not to generate lawyer talk. Gabriel.
Well, so users, I'm not sure that they do care. I heard cynicism from here at the end of the table about the motivations of users, and when the cost is zero, it doesn't get any better than that. So it's hard for me to think that they care much at all. On the other hand, technology companies care a great deal, and I think technology companies care more than in your proverbial 6 years ago example, and more than a lot of entertainment and content owners think. So I'd like to bring back to your social media principles, because I think I hear cynicism about those principles, that there's high-minded ideals that really are sort of meaningless and not really easy to implement. But I actually disagree. I think there's a very useful kernel in the social media principles that allows this business, allows user-generated content to move forward, and it's this. Before them, if a technology company wanted to do content review and either technologically or manually filter and look at the content that's being uploaded to determine whether it's infringing or not, there was kind of a dilemma in that once you exercise the right and ability to control content that's being uploaded, you may be taken out of the safe harbor that the DMCA provides you. Mm-hmm. So what do? You either put your head in the sand and say, oh gosh, we don't know a thing until we get a notice and takedown. Or you review every piece of content manually, and sure, it's subject to the whims and the cultural literacy of the reviewer, but that could be a pretty effective device. But there's a disincentive for that. The principles state, it's not law, but it states that, hey, this is one of the things that we, a bunch of big content owners, can get behind. If you're doing manual review or technological review, we think that's sort of playing fair. And at the very least, it's a matter of comfort. It paves the way forward. So that didn't answer your question.
No, it did, because I think it's fascinating, because in the Microsoft sense, and maybe volleyball style set put for you here. In the Microsoft sense, we had many discussions about this, and that company firmly cared. But one of my points I made is, look, if YouTube goes legit, Stick'em won't. If Stick'em goes legit, the next site won't. Right? There is an incentive to figure out how to get content to people for free. And there's apparently a strong willingness on behalf of consumers to view that. And on the truth cycle, there seems to be a strong proclivity for folks to read stuff that kind of backs up their belief versus being true. So, set putting to you.
Well, I think education is certainly important, and the reality is whatever the laws are, whatever the rules are, there's always going to be some person or entity, someone that's violating them. But I don't think that means that we should say you ignore them. I mean, the reality is there actually is a legal regime that applies to direct-to-promote sites laws and wikis. There really are two principal statutes that allow companies to operate. but there's also a certain amount of uncertainty. And that's really where issues like the UGC principles come in. The two main laws that allow companies to operate in this space without the fear that just by allowing users to do things they're going to get sued out of existence are one, the Communications Decency Act, which provides a very broad exemption for a lot of things, including the type of speech that you see on wikis. And again, it's not a perfect law, but this is an exemption that Congress created. And then in the copyright area, rather than an exemption, there's essentially a bargain that was struck called the Digital Millennium Copyright Act, which requires service providers to do certain things and copyright providers to do certain things. It doesn't address all the questions, but it allows a company to operate and allow people to post material if they operate a notice and takedown mechanism. The big mistake that most companies that operate in this space make is they think that as long as they have notice and takedown, they're fully compliant with the DMCA and they're insulated from liability. And that's not true. There are two other main provisions of the statute that are extremely important. You have to disable access to or remove material not only when you get a notice, but if you have actual knowledge or reasonable awareness. And this goes back to your point about sticking your head in the sand. The reality is, if you operate a site, of course you know at certain points in time what's on the site. There's not an obligation to police it 24/7. But if you see something there and it raises what's called a red flag and you don't act on that, then even if you take down all the material responding to notices, you don't have the DMCA protection. The other thing you have to do is you have to have a policy of terminating repeat infringers, and you actually have to implement it. If you do all those things, then it's a quid pro quo. Then you've limited your liability. If you only do some of those things, though, you may not have that liability. What the UGC principles do, which I think is a very good thing, because as a litigator, and I have a lot of fun going to court and litigating to these kind of issues, but the reality is from a business perspective, it's much better when you have principles that people can say, you should do these things because it will deter infringement. Now, this is not a safe harbor. It doesn't mean if you do these things, someone won't sue you. But the fact that you have content companies and technology companies and social networking sites coming together and saying, in addition to what the law requires, we think these are best practices, I think it's a good thing, and it's probably a good segue into...
Oh, yes, but one just interruption, because I'd love to build on this. First of all, I've never seen a man more patiently wait at a panel to say something. I just want to get that was really impressive. A few times I saw this interesting color on your face. Just question before you roll in the rest of this. Wouldn't it just cut out the middleman if you just sued all the advertisers who supported these sites?
Well, those are largely our advertisers.
And they're wonderfully kind, good people who are impacting the culture.
That being said, I do want to say,
If you get up on the mic, because that guy's going to freak out.
It is the whole issue of advertising and on sites and revenue models of piracy sites is something we are focusing on quite intensely. Can't really say much, not really in a position to say much more than that at this point, but it is definitely some aspect of the problem. We're focused on much less on the brand. I mean, the brand side is about business relationships, the other issues a little bit more related to ad networks and search advertising. To the extent it supports piracy. But I suppose that might be, if that could be achieved within the budget, pursuing litigation, that might be a silver bullet. But I'm glad that Ian sort of shifted the conversation more toward the site operators, because we started out talking about users, and really this is an issue about commercial activity and commercial business planning by people who choose to start a UGC site or a social media site as opposed to opening a bakery or a car wash. Nobody holds a gun to anyone's head and says, you must start a UGC site or you must start a social media network, so a social network. This is a business choice, and the point is that if you are going to do that and pursue that as your chosen business enterprise, what comes along with that sort of responsibility. And this is an analogy, perhaps not a perfect one, but there was a time in this country, in this world, where you could start a bank without having a money laundering. an anti-money laundering unit.
I'm glad you clarified that.
A unit that's specifically addressed to preventing the use of your bank for money. You can't do that. You have to have laws changed, and you now have to prevent that. And by analogy, if you were going to start a site like this and be a responsible law, what the UGC principles attempt to capture is a set of basic guidelines and sort of grand arguments that will govern that kind of business model, because it's business. Okay, it's not anything, it is commercial activity. Essentially, I certainly don't have time to go through the whole minutiae of the UGC principles, but the basic concept behind it is a little more than what you summarized at the outset. It's really that if you have a site that accepts user-generated content, and you employ appropriate technology or manual processes to prevent the upload of unauthorized copyrighted material to your site, and you do that in good faith, in a manner that is appropriate to the scale of your site and the scale of the problem you're going to be facing. The content companies who have signed on to this have said, if you behave in that way, we will not bring lawsuits against you when, despite those good faith efforts, some material winds up on your site that shouldn't be. And we won't use them, equally importantly, we won't use the fact of your having engaged in such preventive measures we don't want to use it against you in any way. And to some extent, I think, on the BNCA discussion, I think it undoes, in a private way, without the need for act of Congress, some of the screwy logic that's built into the BNCA, which people on this sort of called the copy left movement have been, whispering in the ears of UGC site operators, don't use technology, don't use manual review, because that's going to give you the knowledge that will defeat your entitlement to a safe harbor, and it undoes that kind of crazy disincentive to engage in appropriate preventive measures.
So, Gilsman, what do you do?
So, I actually think that's a great point. The safe harbor laws, in some ways, do restrict what we can do to filter without taking on additional liability. But what I think most people don't realize is there are ways to allow your users to do more. So there are sites that allow you to flag a video that's inappropriate or some content that's inappropriate. We go significantly further, and we think it frankly makes us a friend of those in the media business. We allow our users to delete bad content without our review. We allow them to block bad users without our review, because we think they're mature adults and they'll probably do the right thing. And if they don't, we can always fix it later.
Hey, Gil.
So I think there are things you can do to be proactive without violating the liability shield of the MCA.
So 2 questions, and I want to transition into truth and reporting and citizen journalism and get into the case of the wiki and Brian work in the idea of consumers defining brands and then bring back the lawyers. But a couple things. Remember when the Dig kids decided to post the DVD unencryption code at Dig? And then the Dig CEO said, "Oh, wait, take that down." And then the Dig kids posted an article about how he was a sellout jackass. Was, I think, what they call him, but that's a legal phrase. Then that found its way back on the dig.com. And then someone wrote an article that got digged up to the top that was the directions to the CEO of Dig's house, with a note from him saying, "Hey, I'm going to be gone for 2 days. The keys are under the doormat. Please don't use the master bedroom. The hot tub's fine." And by the way, the problem was it was his actual home address. Point 1, communities morph into movements. Daniel, the reason that I was making this point about the users is this: as someone who spent a lot of time on technology companies, I promise you that the necessity of a consumer using a site like YouTube is going away. right? I sat in my best friend's basement and watched his 11-year-old build a video game from raw code that he read about over a period of a couple of weeks. Right? So consumers can have the ability to post what consumers want to post. In other words, they can build their own upload sites, their own upload capability, their own transcoders. They can do this on their own. They can throw to live TV. So that's why I believe we're headed down to either education, disruption, stopping, or changing the business model. So we can come back to that with questions. I want to get into the wiki topic. 2 points of view here, right? Brian has said that they impact culture on behalf of their companies, on behalf of brands. And they're happy to let the consumer cloud sort of help define who they are. But let's start with this topic of truth. Judd, I'm going to give you exactly 2 minutes to talk about your situation with Wiki as regards truth and edit, re-edit, and how that went down starting now.
Okay. 2 minutes.
I'll give you 2.5. Go.
Well, let me say, okay, so starting when exactly? Because it's like...
Now.
No. Where in history of
Judd, you were investigating stock manipulation via social media, and you posted to an article on Wikipedia, and you found that someone then removed your post, and you reposted, and then?
Got it. Okay. So basically, okay, so it works like this. I have been, as part of this podcast series I was doing, I interviewed a guy, Patrick Burr. He's a
Could you speak more into the mic, please?
Pardon me?
More into the mic?
How about that?
Awesome.
Okay, so I was creating this podcast series, interviewed Patrick Bird, the CEO of Overstock, this long before I was working there. And in the course of that conversation, it actually ended up being a 4-hour-long thing. He ended up telling me a lot about his life and a lot about this crusade he's on to try to combat this form of stock manipulation. He told me, he predicted there were certain things I would see when I started working, certain things I would see regarding like the public face of this network. I started doing some investigating because I actually have a background in journalism. And I saw the things he predicted I would see. In particular, I saw that a lot of this was being done by one person who used to work in this building, actually, the former journalist himself. That took me to Wikipedia, where some of the work I was doing through my podcast series got posted to the article about this form of stock fraud. That's the first time I really became immediately aware of it. Well, somebody posted it. I noticed somebody else took it down. Somebody else put it back up. Somebody else took it down. Pretty soon, I was the one putting it back up, and somebody else was putting it down. I went on to learn that this person who insisted on taking it down was this guy, this former journalist who had created several identities on Wikipedia and was using them to severely skew the articles on Patrick Byrne, on Overstock.com, and on this an article about this form of stock fraud. He also used those identities to create the article about himself, which is a little bit. But when I brought this to the attention of the Wikipedia community, I thought I would be held up as a hero, like, oh, thank you for making us aware of this terrible conflict of interest, etc. Instead, it became public enemy #1 because I had violated another rule against outing people. So there's this tenet which says that everybody on Wikipedia deserves to be anonymous. There's also this tenet that says there should be no conflicts of interest. I apparently got stuck in the middle of this Kafkaesque, like, because if you have a conflict of interest, then you must have lost your anonymity. So I kind of got stuck in the middle of this. It became, public enemy #1, and every effort I tried to make to bring the community's attention that these abuses were taking place were responded by making me public enemy #1 even to a greater degree, and it's taken a lot.
So the response to the moderator of that section was? Of the section you read.
Oh, so
slim version.
Yeah. So the response. I basically said this. You can't. You have to do something about this. And she said, you outed this fellow, and that's and so you're now banned for life. You can't. Is that agreed?
Yeah, and you believe slim version to be.
Oh, okay. Well.
In 20 seconds.
Okay. Well, it just happens that she was a classmate of Patrick Burns 20 years ago in Oxford. These aren't things we see.
Yeah, so what's happened is the page has been frozen. It's in dispute. Truth is in dispute. Wikipedia claims one thing, Judd claims another. I want to take this as an example of a couple things. One, Jimmy Wales has said Wikipedia is not a democracy. He's also said it's a democracy. Right? So in terms of defining truth and the role of social responsibility, now someone similar is deciding what's true about a really important issue around manipulating public stocks. This also can work on behalf or against brands. Brian, you have a brand page on Wikipedia. Someone edits it with something demonstrably untrue. You re-edit it. At what point do you sue? At what point do you pursue legal action? At what point do you do that with your brand versus trying to impact culture? And Jed, would you hand Brian?
I don't know. Never anything I worked on has gotten to that point. And generally suing people does not endear you to them, even the ones that you're not suing. So it's, at least in the marketing context, I can't imagine we would, that would be a path we would prefer to choose. I mean, I guess, there's a really interesting thing happening in Madison Avenue these days, in that we're sort of realizing with all those wonderful tools that help consumers create, share, and curate content. This notion that consumers can participate in defining brands and what those brand experiences are. It's also making us realize that we have to really fundamentally change the way we work with our clients. We're advertising a very campaign-based approach. So you have a start date and end date, you have a whole bunch of work that goes on, and then the campaign ends, and you go, all right, what's next? But really these things sort of take on a life of their own and require sort of an ongoing commitment, which we kind of do in the PR discipline, but not in the advertising discipline so much. So what we're trying to get to is understand, as we sort of spin off these little eddies of conversations related to our brands, we have to have a resource, that's part of the team that can participate in those dialogue. Not necessarily to squash it or sue it, but just sort of participate. And hopefully our client's version of the truth will be fairly represented.
Okay, so genuinely speaking, and full disclosure, Brian and I have been friends for many years, so I get to make comments like this, hopefully, and maintain our friendship. If someone wrote on a wiki that Intel chips were, say, made from cute baby seals. And by the way, Intel chips are not made from cute baby seals. You would be satisfied to participate in that discussion and say, well, we don't think so.
Well, I mean, we would say that in the, you're asking the ad guy as opposed to the legal.
We're going to get to the lawyers.
But we would say that if that was in a public forum where that debate was going to go down, that we think that Intel would be best represented by saying, actually, no, we're not. And here's actually the guy who makes the chips, and you can hear directly from him what they do, and let people decide what they believe truth to be.
Cool. So we're going to now do a little flow here because we have a lawyer here who worked on a case of a very, very well-known journalist. That's all I'll say. We're going to roll back the special person in a moment. But Gil, so before we get to the question we have with Jed and Truth, are you familiar with the service called Subvert and Profit? No. Raise your all's hands if you're familiar with the site called Subvert and Profit. This is a great site. This is where you, a brand marketer, a PR person, a presidential candidate, can pay people to vote you up on big, delicious Reddit. So you got 20 grand to spend, they will pay X cents, dollars per vote. And boom, by way of economic magic, you're number one on Dig. Right? Or you have a bunch of edits to a wiki page.
Is that sort of like the way I pay extra to get good shelf space in the grocery store?
Yes, it is, except that it is undisclosed. That's called a stocking fee.
It's disclosed to me when I go in the store.
Oh, no, not to you. No, not at all. No, that's completely hidden and below board and really mean. So, with that in mind, and I don't mean to impugn by any stretch, but I just add some color to the conversation. You heard Judge State, we heard Brian. How are you approaching this? And then we're going to get into the lawyers.
Well, I was, I have a lot of respect for what John does. And as I listened to his angst and clearly sense of frustration about this, I could picture Judd going to our Christianity wiki and arguing that Jesus was not reborn, and having them delete it, and having him put it back, and having them delete it, and getting into a confrontation with a bunch of people, and eventually being banned from the Christianity wiki because he doesn't believe that Jesus really lived and was reborn. So each of these sites, whether it's Dig or Wikia or any site, Overstock has their own Web 2.0 site. They have their own wars, they have their own culture. Some of them are trying to do good. Some of them are ambivalent about good, and some of them, frankly, are not trying to do good.
So let's take it from, since you're using the example of Christianity and an example of Judd, and the two may be related, I don't know. Actually, I do know. Let's use the made-up example of Intel chips being made from what they're not made from. They're made from silicon, but made from. Well, should I change that? Let's say AMD. We know those are made from
I
data
get
chips.
a call from Intel, and they say, there's stuff on your page that we find insulting and repulsive. And I say, hey, have you been to the page? And they say, yeah, we have it up right here on our computer. And I say, do you see the edit button and the delete button?
And if they delete it and it comes back, and next week AMD are made from living cute white baby seals.
Well, what we find is that companies can get involved. On our site, we don't have a problem with companies getting involved. I also find that our users, because we spend a lot of time talking to them about this, they take on the role of identifying bad content and blocking bad content and blocking bad people.
Okay.
So, I think we have a bunch of processes in place. Are they perfect? No. Is current media journalism perfect and always gets the story right? No. You have to have safeguards. You have safeguards, you have processes, you try to have as much transparency as possible so that people can investigate. You try to show your sources so that people have an opportunity to fact check. What wikis are really good for, because of the nature of the software, we have version control. We can see every change that was made, you can see who made it, the person keeps making what you view as nefarious changes, you can track them, keep an eye on all their changes. It's about, democracy is about responsibility and not just freedom, right? It's about a combination of both. And we try to build a system and a culture and a set of software that enables people to be free, but also provides safeguards and tools for folks who want to be part of the volunteer police force.
Excellent. And by the way, I thought that you were doing a setup for me there. When I was saying you're good, but you are very good. We should do so. All right. About 25, maybe 30 years ago now, a journalist named Dan Rather did an investigative piece of insane Vietnam veterans living in trees in Washington State, like literally living in trees. It talked to them on camera. They had horrific tales of killing truckloads full of babies and of ruining villages in Vietnam. Really, really horrific stuff. And just the slightest problem with that was that none of them had been in combat. A couple of them had been in theater, but in non-combat positions. The vast majority of them had never served in the armed forces. The statement at the time by CBS Management and Dan Rather went very much along the lines of, while there were some problems with the facts of the story, we stand by its tone. Now, a couple of years ago, a memo came out that questioned President Bush's military service in the National Guard, and I don't know if you've heard, but some people don't like Bush. This memo made it on CBS News to a producer named Mary Mapes, right, who was, by the way, turns out, a Democratic activist, and etc., came sourced from someone who was a Democratic activist, but made the desk at Dan Rather, whose job was to report the news, and read. Now, Jane can't go into detail on this because she was involved in the case, but something different happened this time around. When that memo hit the screen, someone obsessed with, and I'm not kidding, someone obsessed with typewriters looked at that memo and said, that's a sans serif font, that's a sans serif font, that's a sans serif font. And as you all know, sans serif fonts didn't exist on typewriters. So in the old days, he would have ended up in the freak stalker file at CBS News saying, guys obsessed with typewriters. But in this age, his little tiny blog took off because he did a document comparison and said, you know what? That was typed on a word processor. To be specific, Microsoft Word 95. To be specific, this service pack. And now, a pretty vicious attack, some people say, of Dan Rather occurred, trying to determine now what was truth, from Gil to Judd to Brian, who's Brian's appearing this, and we'll roll up into this, the litigation. So in that case, you really had a group of bloggers come around and do what, Jane, in your opinion, as much as you're able to say, because you have a case, and up on the mic.
Well, I was part of the Dan Rather defense team, and it is a pending litigation, so I can't say much. But clearly, the bloggers shaped what occurred immediately, and it was the immediacy of their access to the public to air their views, to bring up this point about the bond, which they thought was well documented. There was contrary evidence to that, but the impact of the blogosphere, of these groups of people who have an agenda to shape history in a way, immediately is, I think, what is so remarkable about the internet and where we have come and the access of you and me and anyone who wants to get up there and write about it. And get into the truth. Clearly, this blogger thought he was putting up, consistent with his First Amendment rights, what he perceived to be the truth. As a litigator, having done this for so many years, I certainly come to believe that people believe that there are many truths. There's a story that your client comes in and tells you. There's the story that the defendant or the other side of the case is going to tell you, and probably the truth is somewhere in the middle. And that's why we have courts. We can't resolve it. People go to courts, and the truth ultimately is decided by a judge or by a jury. That process doesn't really work, I don't think, all that well in our current internet age. You can't have people suing all the time. You do have all these different groups. You do have all these different sides of the stories. I don't know that a situation, in my view, I guess this is personal rather than legal, where in the wiki, where you have people constantly taking things on and off and editing and changing, and it goes back on, it goes off. Ultimately, I don't know that does get you to the truth. Maybe the situation we're talking about, the different views being aired and having people having an opportunity to look at the different perspectives and different facts and different views of the truth side by side and make their own assessment of what the truth is perhaps a better way than this constant revision and changing. Because people are always going to want to put their version of the truth into the article or the blog or the piece of necessity.
Okay, so I think that's interesting and well said. There's a lot of ranges to this. We're going to get to questions in about 4 minutes here. Note to the panelists. There's some legislation that's been proposed. That some senators have proposed that would actually register bloggers who make X amount of money from advertising as lobbyists. And then they'd have to live by the rules of lobbyists, not then the rules of journalists. So just add a little more color. And we're going to get to, because you're sitting forward, you look like you're going to answer this, but I'm going to go to the very patient Dan for a reason. For a reason. Dan, I mean, you probably, as I understand it, might end up, or someone who works with you might end up defending, say, Brian Williams. If a similar, something similar happened in NBC News. No, I mean, I can't imagine NBC News anyone would ever question anything you say, because you've never done anything wrong. But with this story in mind, what's the lawyer in you say about this culture of this editing culture?
I guess the reality is we have this technology is here, and it's it is fantastic technology that can be used for terrific purposes, and as we've seen in this and other technological contexts, can be used improperly and for nefarious purposes. I think it's it's the reality that bloggers who have time and bandwidth are going to be able to do this, and it's a reality we have to live with. And if they come up with a gotcha laws, one for the internet and one for every other area. We have sets of laws that have developed over hundreds and thousands of years that are finding a new form for application. And except where Congress has specifically, or maybe some states, but it's really a federal issue, have made some special rules. Our task as lawyers is going to be to take the old rules and apply them to the new facts, and it's going to shake out as it will shake out.
Okay. Good. And of course, there are only the special case of two laws is for us in Congress. Ian.
Well, I mean, I think certainly, the internet initially changed the playing field, and certainly with Web 2.0, it's just amplified the effect. 30 years ago, you used to have money or a platform in order to get your message across, and now the dynamics have completely changed. It's oftentimes the people with tremendous amounts of time on their hands that get the message out the most. But the reality is, in the United States, we have the First Amendment, and that's a good thing. The way we sort these things out is to let all the information come forward. And so we're dealing with a different playing field, but to a large extent, we have, first of all, the First Amendment, and then second of all, the CDA, which provides a very broad exemption for intermediaries. So that doesn't mean that if an individual defames someone on a blog, they themselves can't be held liable, but it does mean that it's very, very difficult, if not impossible, to hold a blog operator liable, and that to a large extent, in the United States, we've decided to balance that to err on the side of free speech. Now, internationally, it's very different, and you'll see that in different countries, they regulate speech to a great extent. And when you're operating blogs internationally, you have to be very careful. In Europe, they've noticed a takedown mechanism somewhat similar to what we have through the MCA. But here, really, you're dealing with that. Now, the problem in anonymity is when there really are torts or crimes that are committed anonymously, then because of the CDA, and not even so much the CDA, but because of the First Amendment, it's very difficult for companies to try to find out who's responsible. And I've litigated those cases in many different states, and frankly, there's a patchwork of different remedies, and in different places you have different issues that you have to deal with. In my home state of California, there's something called an anti-SLAPP statute that means if you go after someone's anonymity and you're wrong, you not only may get the case dismissed, but you often get attorney's fees. In other states, you have to petition the court. I have a trade secret case in Texas where someone actually posted trade secrets on the internet. We went into court. We said we need to compel the disclosure date end of this person. The judge looked at the motion. He thought it was interesting. He thought about it for a while. He left for a summer vacation. He came back. Eventually, he ruled in our favor, but that was 3 months later. And it's lucky my client wanted damages, not injunctively. So it's quite different. And you have to, if you're a company, you have to think really strategically, because otherwise you're going to do two things. You're going to spend a lot of money where the result may be unclear, or you may really have no remedy. Or number two, you spend a lot of money so that the blogs explode with negative publicity. So there are instances when you want to do these things, but you really have to think carefully about it, and it really has to involve a crime or a serious tort, not just the fact that you're upset about what's happening.
Great. We're going to transition to questions quickly. As a method to keep you hanging, I would like the lawyers, forgive me, Judd and Brian, unless you want to play the game. We're going great. I would like you to, on a piece of paper, answer the following question with a number 1 or number 10. On average, the members of the brilliant federal judiciary's knowledge of technology is 1, insipid, 2, vast, expansive, and all-knowing. Or let's do it better. 1 is none. So the average judge to whom you're expected to go complain, present, has how much knowledge of technology?
Is this between 1 and 2 or
1 and 10. 1 being level of like myself. None. Federal judge. Let's take average. Let's take the average federal judge. Just whatever you all lawyers call it. Now, questions from the audience. We have about 7 minutes. Yes, sir.
I have to follow up just on the point of anonymity, and I'm from Denmark. I noticed over here a lot of sites they don't allow users, to use kind of names or those anonymous names when they participate. And our media, our website, we only allow people to register with the full given name, because the principle being that's how we do in the media. I mean, they'll bring in a newspaper, somebody with an anonymous name, or anonymous sources are only used in very specific cases, and then we know the name, but we don't disclose it to the public. So my point being that does the media have responsibility here, like how they allow people to be in the site? It's a big point for Wikipedia. We have an anonymous person source. So the real question is, can anonymity and accountability, those two coexist?
Okay, good. So let me reframe the question for the mics. From Denmark, question on journalism of the idea of anonymous people being allowed to post in Denmark. This isn't allowed.
Oh, it's allowed, but we just
okay,
allow
they shoot it. I know a little about journalism in Denmark. Which is trying to rephrase.
He's saying that in his company, his site.
Oh, on his site. In his site in particular, they make people actually be real people and divulge real names. So, question is, well stated. Can anonymity and responsibility and accountability, can those things exist together? Can one be both anonymous and accountable and responsible? Judd?
I think there's no way. Now, certainly there's all sorts of case law which says that the First Amendment allows for anonymous speech, and that's fine. But even just like you zoom out from a completely practical level, I have no idea how this actually works. In the sense that, like, you go to Wikipedia and we spend so much time trying to say that we're not a publisher, but a service provider. Well, when Wikipedia's kind of transcended into something, I mean, very different. It is a primary source of information for many people now. The licensing under which people contribute content to Wikipedia basically says that, if you retain the copyright to what you contribute, but you can't stop us from doing anything with it. Well, now, the question then becomes, in cases where slanderous or libelous material is contributed, that license also says you are responsible for it. We, as the web host, are not responsible. It's you. But see, there is no official recognition of who the you is. So if you decide to exercise your right to anonymity, it's at some point, and I'm just shocked this hasn't happened yet, there is going to be a major blowover. The courts are going to be forced to look at this and say, well, no, this is a very good point. The licensing says this, but there is this tremendous gap between what it says and who's responsible, because officially, you're saying they have the right to remain anonymous. So I think 99% of these tremendous abuses that we observe on Wikipedia specifically, and in these Web 2.0, social media generally, go away as soon as anonymity becomes. As soon as anonymity goes, I don't think you can do that, but I think we need to work to instill a culture where anonymous people's opinions, et cetera, are not valued as much as anonymous.
Gil, I sense you're going to respond to this, so but let me ask you a question, and feel free to frame your response if you like. But do you think, in fact, that we should require people we content or platform providers should require people to identify themselves?
I think, the principles we organize the country on are the same as the principles that we organize our site on, which is that people should have choice. And given the choice between an anonymous person providing me links to Library of Congress information that appears reputable, and a friend of mine telling me what the law is, I'll take the anonymous person who appears more credible. But when I go to the restaurant bathroom and I see something written on the wall by an anonymous person, I probably don't believe it. So I think we actually do have a culture of understanding the difference between what an anonymous person says and what a reputable person says. And reporters do the same thing. They get anonymous tips. Those are very useful. But they don't write stories based entirely on those.
Unless they're the New York Times and they're writing about sexual dalliances or pretended they're other junk.
No one's perfect. Certainly not us either. But I think it's a matter of choice for the interviewer. It's a matter of choice for the reader. And at the end of the day, websites track your IP address. Your ISP has your IP address. Lawyers can go to the ISP and compel them to provide information about you. No one is actually anonymous, as we found out from today's stories about the government tracking your money transfers between banks. This notion of pure anonymity is not true. It's just a question of how much work it is, or if you have to spend a summer waiting for a judge to compel people to do the right thing. So people have a perception of anonymity that may exceed the actual, and that perhaps is where some of that behavior comes.
Okay, so roughly 2 minutes left, and so McNeil, Laughlin type, wrong, yes.
With respect to user-generated content on a website like YouTube or Facebook, isn't the provider actually serving as an agent for discovery of new talent, very much like a William Morris or an ICM, in that if a user gets discovered on that website, okay, there would then be a conflict with Google's partners?
I don't think I understand the Google's partners thing, but
Well, what I'm talking about is, with respect to the getting discovered on a user-generated website, okay, the ISP is actually, well, the web provider is actually serving as an agent. Okay, it's not just.
so I got that part. I just didn't get the part about Google.
Okay, well, no, my question is with respect to the discovery or with its own partners that may then want to, let's say, create a label with somebody posting video or something on the internet. Isn't there an inherent conflict of interest?
So good question for lawyers, because conflict of interest is your game.
I don't think there's a conflict of interest. I mean, it's a forum where people post things, and you're right. I mean, there's not just infringing content. There's also chocolate rain. There's snowman asking the Democratic presidential candidates questions. It's a smorgasbord of different things.
And that's really what user-generated content is. I mean, user-generated content is a large measure of misnomer.
Has anybody decided the issue of agency with respect to a web provider? Whether they're entitled to some commission or not. It's not whether it's whether you're saying that there's no liability for a web provider for posting user-generated content. I'm claiming in the area of creative, undiscovered content, there should be liability of some kind. This issue hasn't actually been pursued.
So we will have to pursue that on the next panel, because I'm getting the signal from a very big man who warned me. So now, reality show like, the question was, and yes, we can play with which judges, but on a whole, the federal judiciary, the knowledge the judges hold of technology is on 1-0 to that of omnipotence. Reveal your answers to the folks. Oh, I was going to have you hold it up. You didn't actually play the game, did you? You didn't write it down. Okay, so we'll go quickly. Shannon.
I put 4.5.
4.5.
It could have been any number.
That's very fair, and you have to step in front of them. And yeah.
I said 7.
Nice. Wow, you're going to do well in court.
Yeah.
Yeah.
I also said 7, not so much because of the judges, but because they have recent law graduates as clerks.
Great. That makes me feel better then.
I said
4 to 5. Okay, very good. Gil, did you play the game?
I have no legal basis.
Yeah, me either. Okay. Ladies and gentlemen, the panel.